going to talk about efforts to enact legislation in the United States Congress to ban asbestos in the United States. Briefly, the background of this is that the EPA tried to ban asbestos in all of its major uses and regulations that were developed in the late 1980s. The rules were overturned in a court decision in 1991. The Justice Department under Bush 1 twice refused to let the EPA appeal the court's decision, and so that part of the Toxic Substances Control Act, which should have been available to ban things, it has not been used since 1991 to ban anything. And so the battle goes back to Congress to now ban asbestos by an act of Congress rather than by using the provisions of the Toxic Substances Act. With the elections in 2006, the Democrats took control of both houses of Congress, and instead of arguing about bailout bills for the asbestos defendants, we got to talk about prevention and move forward with the efforts to ban asbestos in the United States. There were several hearings in the Senate last March and June, and then after the hearings, as you were told, there was a critical change made to the legislation in the Senate where one word was changed. And it was changed, the action part of the bill, the part that talks about what's banned, changed the banned materials from asbestos-containing products to asbestos-containing materials. This didn't seem to be a big deal at a superficial glance, but this change refers back. What the law does is it amends, what the Ban Asbestos Bill does is amend something called the Toxic Substances Control Act with a different additional provision. By using the term asbestos-containing material, it references something that's already defined in the law from the 1970s as 1% and above. And so this very dirty trick was done at the very last minute in the Senate, and that's why the thing sailed through the Senate by unanimous consent, because the stone, sand, and gravel people said, we like that just fine. And the mining industry said, looks all right to us. And so that's how it went through the Senate. So now we have to fix this in the House. You've heard abundant presentations to describe the fact that 1% of asbestos, or half a pound of asbestos in a 25-pound bag of joint compound, is not a safe concentration or content of asbestos. The problem is bulk sample analysis is something that is difficult. And the methodology, even today, doesn't go down a whole lot below that. In California, the California Air Pollution Control Board has a 0.25% limit, so that if a sample is analyzed as having that amount, it cannot be used for construction, in construction material. And so we have big concerns. Our concerns are, just to list them, there's crushed stone, as I mentioned, in quarries that can contain asbestos. It's the taconite ore, it's iron ore that's mined in Minnesota, where you've heard that workers have died from mesothelioma from working with that stuff. It's talc from upstate New York and other places that can be contaminated with asbestos. Vanderbilt talc, Vanderbilt as in the public be damned, is the name of a company that mined talc in upstate New York, and even while the mesotheliomas were accumulating among their workforce, steadfastly denied that there was asbestos in the talc and marketed the talc as if it was asbestos-free. So Vanderbilt is closing their mines this year because of the difficulty of selling that material, but it wasn't for want of trying to sell it in the way that they tried to sell it, as if it didn't have asbestos in it. So now in the House bill, there are a number of changes that are going to be made. Just before I go from the 1%, by way of enforcement, by way of having a method of analysis to enforce a ban, you have to say how you're going to analyze stuff to see if it has asbestos or not. That's the problem that we're left with. And you can do it by stirring it up and seeing if it causes asbestos in the air, as Dr. Miller suggested. If you're doing bulk analysis, Germany and Japan go down to 0.1%. So that's 1/10 of the 1% limit that would be in the Senate bill. And so I think we're going to try and get to that, or at least get to 0.25% with the EPA assigned the task of continuing to develop lower concentrations and document the hazards at that concentration. The House bill, the differences between the House bill and the Senate bill are the House bill is going to make the ban statutory instead of something that's going through EPA rulemaking. EPA rulemaking can be a very protracted affair. So rather than assign the job to the EPA to carry out the ban through rulemaking, the House bill would simply say it's done. After a certain period of time, no more asbestos-containing products can be sold in the United States. That's the other change from the Senate to the House bill that's being developed now. The House bill would also require that the EPA implement a public education campaign. The Senate bill says that the EPA shall develop plans for a public information campaign, and it provides no means for civil petitions brought by the public. The House bill says that the EPA will not just plan for a public education campaign, but they will implement a public information campaign, and it does provide for civil society to petition the EPA and sue the EPA over such things as that. The House bill also would make violations of the law a felony, punished by up to 5 years in jail. The Senate bill refers back to the general penalty provisions in the Toxic Substances Act, which basically treat all violations as nothing worse than misdemeanors, punishable by up to 1 year in jail. The House bill has an explicit clause that says this does not preempt state laws or on regulations or liability. So, for example, the California Air Pollution Control Board would not be precluded from setting stricter standards than the federal standards to protect people from asbestos, and liability would not be affected under this law. There's always the concern that when you try and change laws for the purposes of regulation, that there'll be some judge that'll look at that in a liability case and say, well, you've just given me the basis for dismissing this case against this corporation. So there's an explicit provision in the House version of the bill that says, no, this doesn't change any of the pre-existing state laws on regulation or liability. The House bill will require that exemptions, that is, if companies want to continue to sell asbestos-containing materials for a little while, they have to apply for an exemption to the EPA. The House bill will say that the exemptions must be justified by there being no reasonable alternative available. And the Senate bill didn't go that far. It said something like, you have to prove that it's hazardous. The House bill assumes that it's hazardous and says, and you also have to show that there's no reasonable alternative, otherwise it's off the market. Now, the House bill would require for any exemptions that the EPA go through full rulemaking. So it's not something that can be quietly or quickly done. That has to be a public process, and the EPA has to go through full rulemaking to grant exemptions to the ban. So in many ways, the House tightens things up. I mentioned citizen petitions being provided for in the House bill. There are also limits on the asbestos content of sodium hydroxide. There's an exemption for one exemption in the bill, a statutory exemption for the use of asbestos in certain types of chlorine manufacturing plants, diaphragm cell chloralkali plants. And this is a 3-year exemption that has to then be renewed by the chlorine industry. So we had to wait till the next administration to do anything about this. Anyway, we decided to give them a short statutory exemption and then make them justify it after that. In drafting the Senate bill, and the House bill would additionally set limits on the asbestos that can be in the lye, the sodium hydroxide. That's the product of one of the products of the chlorine plants. They make chlorine and alkali. And so the lye has asbestos fibers floating around in it because of the use of the diaphragm in some, but not all, of these chloralkali plants. The EPA is also, under the House bill, going to have to specify activity-based tests of the type that Dr. Miller mentioned, so that you don't just do bulk analysis, you stir the stuff up in some kind of a test chamber and see if there's any asbestos in the air above it when you do that. There was also an incoherent clause in the Senate bill which nobody could either explain or say how it got there. And so that's being dropped in the Senate bill. That's lines 14 to 18 on page 23. If anybody wants to look and try and figure out what it means, I can't. But I'm sure somebody had something in mind when that was included in the bill. Briefly, a rundown on what's going on in the courts. As you know, there are several 100,000 personal injury claims pending in the courts in the United States for individuals alleging to have asbestos-related disease. The cases that go to court are almost all cancer cases. I'm testifying in these cases about the history, the public health and corporate history of asbestos on an increasingly frequent basis. I'm now doing trials at the rate of 2 a month, and for 25 years it averaged 1 a month. I'm doing depositions at the rate of about 70 or more a year. It's unbelievable. Companies continuing to question me about what my opinions are when they know damn well what they are. And they know about the evidence that it's based on. It's not like I learned anything since last month about Craneco or any of these other defendants. There was one interesting case that just came to verdict involving Metropolitan Life. I mean, you know that some of these cases are product liability, some are premises owner liability, like oil companies contracting Halliburton to come in and do the turnarounds on their refineries and let Halliburton's workers get the asbestos exposure and hope that wouldn't come back to haunt the oil companies. Well, it has in the form of premises owner liability for their failure to warn and protect people against mortal hazards that they know of or should have known of in their industrial premises when they brought people in there. But in addition to product liability and premises owner liability, there also is the possibility of companies being defendants on the issue of conspiracy. And it prominently includes Metropolitan Life Insurance Company, in this case because Dr. Anthony Lanza, you may have heard this name earlier today, he was altering his medical publications in the 1930s, saying that asbestosis is a milder disease than silicosis, under direct correspondence from the lawyers for Johns Manville to weaken the conclusions of his report, and doing other favors for the asbestos mafia. And Dr. Lanza was working with Metropolitan Life for a number of years, and then Metropolitan Life is now being sued for having enabled Johns Manville to harm people. And in the state of California, a case recently came to verdict where the case was decided solely by the judge. There was no jury deciding the case, and the judge found Met liable to the tune of $11 million in the case. And so this is a kind of a breakthrough in California, because California law had been very tough on bringing these kinds of conspiracy claims because of the particular way it's written. Each of the states has its own variation on this business. And so now I think maybe we'll see in California Metropolitan Life starting to pay settlements to people in cases where they had previously been able to get out on summary judgment and not pay anybody but their lawyers. So that concludes basically what I wanted to just sort of tell you by way of a brief update of what's going on, and I hope that the slideshow would, at least generally give you additional information about what it is I was talking about. Thanks.